Hey everyone! Today, we are diving into a fascinating and somewhat controversial topic, the recent court ruling in British Columbia that challenges the way involuntary psychiatric treatment is administered. This case highlights some serious ethical questions and raises important discussions about patient rights and mental health care. So, let's break it down and explore what this ruling means and why it matters. First off, let's set the scene. British Columbia's Mental Health Act allows for forced psychiatric treatment, even for individuals who cannot make their own healthcare decisions. This blanket approach to involuntary care has been called into question by the BC Supreme Court, which ruled that these provisions are unconstitutional. Justice Lauren Blake's decision is a significant one, as it challenges the very foundation of how we treat involuntary psychiatric patients. What makes this case so interesting is the unique nature of BC's system. Unlike other provinces and territories, BC doesn't require an assessment of a patient's capacity to make treatment decisions. Instead, it automatically assigns substitute consent to facility directors, creating a situation where patients are either deemed to consent or are not mentally capable. This legal fiction, as Justice Blake calls it, is a real head-scratcher. The ruling highlights a critical issue, the assumption that all involuntary patients lack the capacity to make treatment decisions. The Council of Canadians with Disabilities, CCD, argued that this assumption is wrong and that it erases an individual's liberty and ability to choose. This raises some serious questions about the ethical implications of involuntary treatment and the potential for trauma and mistrust among patients. Now, let's talk about the broader context. BC is in the midst of expanding its involuntary care system, with plans to create new facilities in Surrey and Prince George. This expansion has sparked controversy, with advocates and critics alike raising concerns about coercion, physical force, and the lack of procedural safeguards. The ruling comes at a crucial time, prompting a re-evaluation of the entire involuntary treatment process. One of the key takeaways from this case is the importance of individualized care. The court heard testimony from patients and their families, who raised concerns about the system overriding the will of substitute decision-makers and the potential for lasting harms. This highlights the need for a more nuanced approach to involuntary treatment, one that takes into account the unique circumstances of each patient. In my opinion, this ruling is a wake-up call for the entire mental health care system. It forces us to confront some difficult questions about the balance between treatment and patient autonomy. Personally, I think it's a step in the right direction towards a more ethical and patient-centered approach to involuntary care. It's a reminder that we need to be constantly evaluating and improving our practices to ensure the best possible care for those in need. So, what does this mean for the future of involuntary psychiatric treatment in BC? Well, it's a complex issue. The BC government has been given 6 months to amend the legislation, but the implications of this ruling could be far-reaching. It may prompt a re-evaluation of involuntary care practices across the country and lead to more stringent safeguards to protect patient rights. In conclusion, this court ruling is a fascinating and thought-provoking development in the field of mental health care. It challenges us to think critically about the ethical implications of involuntary treatment and the importance of individualized care. As we continue to navigate the complexities of mental health care, it's crucial that we remain open to new perspectives and constantly strive to improve the lives of those we serve. Thanks for watching, and I hope this video has sparked some interesting discussions. Don't forget to like, comment, and subscribe for more insightful content. See you next time.